Everybody to today's webinar. So my name is Thomas Adhumeau. I'm Didomi's Chief Privacy Officer. So for those of you who don't know us, we are a global privacy UX solution, and we provide privacy compliance tools such as consent management platform, preference management platform, a DSAR request product, as well as a monitoring solution to make sure that all the trackers and cookies are being monitored on your websites and apps. Now I'd like to introduce our first speaker, so Julia Shullman. I've had the privilege to work with Julia for many years, especially during the rollout of GDPR. Julia currently serves as the General Counsel and Chief Privacy Officers at Telly, one of the most innovative connected TV solution, or like one of the most innovative player in the connected TV space. Julia, actually, can you tell us a little bit about Telly, maybe?
Sure. Thanks, Thomas. So hi, everyone. Thanks for joining today. And as Thomas said, we have worked on and off together over the years. So thank you for the invitation. And it's been a pleasure working with Thomas, both as outside counsel on my same team, and then kind of as an industry peer. But I work at Telly, which is a company that is designing, manufacturing, and distributing dual screen smart TVs. There's kind of three things that differentiate us. One is we actually go direct to consumers, so we're not selling through retailers. Two is we provide the devices for free in exchange for the right to use our users' data, and I'm sure we'll talk about that a little bit later, Thomas. And then the third is, if you didn't catch it, we have two screens on our TV. So we have kind of your traditional theater screen, as you have on any smart TV these days. And we actually have a second device that is attached to it that is a combination of an iPad, a billboard, and a smart home device. So thanks for having me. I'm looking forward to the conversation.
Well, thank you, Julia. And our second speaker is Paul Lanois. Paul is an attorney currently based in California. And Paul has been, like, has a wealth of international experience living in many countries. We were just discussing about it. And Paul works for Fieldfisher, advising companies on data privacy and cyber security matters. So thank you, Paul, for joining us. So before diving into our discussion, it would make sense to walk you through today's agenda. So we will try to divide our webinar into two main parts, even though there's probably going to be overlaps between the two parts. First, we'll try to cover like the most interesting pieces of ad tech innovation, so what's currently going on in the ad tech industry. I mean, there's a lot to unpack, so we're probably going to just focus on the deprecation of third-party cookies, which has been a big theme in the recent years. But also, since we have Julia representing Telly, we're going to focus a bit on CTV, the CTV space, of course. And then we'll try to, again, there's a lot to unpack there, so we're probably going to remain a bit high level, but we'll look at the impact of US state law and the new draft of federal privacy bill, so the American Privacy Right Act, APRA. So that's where we will go. So first part, let's talk a little bit about maybe the deprecation of third-party cookies. Also, sorry, I should say, if you have any question during the webinar, you can use the questions tab on your screen, and Julia and Paul will try to address as many questions as possible. We'll have like a segment towards the end, at the end of the webinar. So don't hesitate to ask any question. So if we look at what's currently going on in the advertising ad tech world, one of the most pressing issues and that has dominated the discussions in the recent years, it feels it's already been like 4 years, I think. It started in 2020. We're talking about the deprecation of third-party cookies, especially with the upcoming changes in Chrome. But more generally, I think there is a trend around signal loss in ad tech that goes a bit beyond the deprecation of third-party cookies. That's creating challenges for companies from a technical standpoint, but also from an operational standpoint. And of course, there's so many solutions that are supposed to fix or solve for the deprecation of third-party cookies. We've got the Google Privacy Sandbox, of course, which is probably the most prominent solution or initiative in this space, but it's not the only solution that's available. Julia, since you're probably one of the best, one of the most knowledgeable experts in the ad tech world, I will start with a quick question. Like, do you think the industry is prepared, despite the fact that it's been discussed for many years, and the fact that it's probably going to get again postponed this year?
I don't think the industry is prepared. I mean, just to kind of quickly highlight it, I'm assuming most folks have sort of read the news at this point around what Google is doing, right? So they're deprecating third-party cookie use in the Chrome browser, and then they're going to move into the Android operating system as well. I think the couple challenges that I've at least seen, and I think you've seen as well, and curious to hear from Paul, is one, they're doing this and replacing it with a privacy-first solution. So they're actually not replacing it with a one-to-one user or device level identifier, but they're proposing a new solution, and it's different based on the different use cases in industry. So some folks in the industry have been testing out that new solution for different use cases, but many in the industry have also been looking to actually replace that identifier that they're taking away with new identifiers. And that brings a couple different challenges. I think one is just the operational. As you mentioned, there's a number of different solutions out there. So there's a bit of a chicken and an egg dance of what to adopt, certainly. And companies, both operationally and technically don't want to have to adopt too many solutions. They have a lot of resources just technically. But two, of course, we're here talking about privacy, are some of the privacy challenges that come along with adopting new identity solutions. And those are some of the same challenges we've all faced time in and time out around transparency. Does the user understand what's going on? User choice. So opt in, opt out. How can you handle that for these types of solutions? Can you technically actually manage opt in or opt out with some of these solutions? Many are actually probabilistic, meaning they're not actually one-to-one associated with a user or device. So they're actually very hard, if not impossible, to manage opt-in or opt-out around. And then just how do you manage everything else around them, from deletion to access, you name it. So it's presenting quite a challenge for the industry to look at those new solutions, think about the privacy challenges around it, think about the operational challenges. And then I don't want to forget that the new solutions that Google is proposing are not necessarily anonymous. So you actually have to look at them under not only the GDPR, but also US state regs and federal opinions and federal requirements and figure out how to comply based on your use of the new signals and the new solutions that Google is proposing.
Have you looked at the report from Criteo?
I have. Yeah.
It was published last week, I think.
Yeah, I took a quick look at it. So I think it's been really interesting to see a number of the larger ad tech providers and their clients, whether they're on the publisher or brand agency side, really trying to provide good, critical, useful feedback on many of these solutions, both from a technical, but also from a privacy perspective. And, we know cookies are sort of this, there's a love-hate relationship, between tech companies, users, and regulators around cookies, but they're maybe not looking so bad these days, given that they're actually something that a user can technically control from their browser versus these new solutions that are being spun up that are actually not the easiest for a user to control and for companies to collaborate on managing user choice around.
What's in your view, what's making it very difficult for individuals to actually control what's going on? What difference do you see with the current state of affairs?
A couple differences. One is there needs to be interoperable. So again, for cookies, users historically could either go into their browser and actually clear their cookies or put in blockers, or there were industry solutions that had kind of a one-stop shop. They could go to one UX and opt out of the use of those cookies for certain uses. Now that there are new identifiers that tend to be associated with hashed emails or hashed phone numbers or other identifiers, the industry needs to have an interoperable solution that users can go to manage choice, and that's very hard to do. And then it's kind of restarting the education for users around how they can understand what's happening. This isn't rocket science, but it is some sophisticated use of various identifiers and how they're passed and used in the ecosystem, and users barely understood cookies, and now we're kind of overcomplicating this even more.
Yeah, that makes sense. Paul, what do you see from advising companies trying to reach a state of compliance? Do they come to you to sort of assess all those solutions that potentially, or do you think they're still waiting to see which solution is going to be the winner out of all of them before trying to adopt one? Do you have do you feel that businesses are actually trying to understand a bit better from a privacy standpoint what's happening with those solutions?
Definitely. I would say that a lot of companies are exploring, analyzing what's going on out there. They are taking a look from a privacy standpoint, to understand what's going on, because they don't want to be, the last one, to do things. So they want to remain like their peers, but then they're not necessarily rushing out to implement those new solutions because, as you say, the wait and see approach. It remains to be seen what will happen, right? From a US standpoint as well, it's not so much about getting cookies consent. That's not so much the issue from a US standpoint. It's more a question of opting out from the disclosure of the information to third parties. What we call selling or sharing personal information, and there have also been quite a number of different tools which have been tested and explored, but then other than the global privacy control, the GPC, nothing has really stood out. But then even if you look at this, global privacy control, the GPC, it still isn't implemented in any of the leading browsers, whether you use Edge, Chrome, Firefox, Safari, or any of the big ones, you don't really have that as well. So you have to actually, like you said, you have to to jump through hoops, right? To have those tools in place. You have to install the third-party extension and so forth to the browser. And frankly, most consumers are not going to be doing that. They don't already, fully understand how cookies work, so they don't understand as well that you have third-party extensions that you have to install and so forth. So, I would say it's a bit slow, at this stage, and I don't really see any massive adoption of those third-party tools, to control privacy, unless they are implemented within a web browser. But then, unless they sign an agreement or any such thing, it's not really going to happen as well, unless there is some kind of mandate or requirement, right, from from a state or from a country to implement those tools. So it is a bit the chicken and the egg issue, I think. Which one comes first? What are we going to do to able to to have more privacy controls? It's still quite unclear at the moment.
And do you think that there's going to be a lot of companies left behind, just because, the level of complexity, at least from a technical standpoint, but also now from a privacy standpoint, in the US, do you think that there's going to be businesses, like the long tail of companies, relying on ad tech or advertising to at least monetize their sites? Do you think they're going to be left behind in a way, or even ad tech players in a way, like the small ad tech vendors could potentially be impacted?
It's always this way, right? For organizations, they want to be in the middle of the pack, not necessarily be in the early adopter, because they don't want to be the one bearing all of the risk, but at the same time, they don't want to be the last one in the pack. So trying to be in the middle is always quite a challenge. And I would say that there is definitely more scrutiny going on from a regulatory standpoint, whether it's ads in mobile mobile apps or in the mobile games and so forth. Just in just a few weeks ago, there was this big enforcement action as well, from the California Privacy Protection Agency against a developer of a mobile games. And what was really interesting, other than the fact that there was a big monetary fine as well, I think it was 500,000 US dollars. It was the fact that according to the investigation, we found that actually the developer had used a software development kit, an SDK, and they didn't necessarily fully understand how it worked. So there was a misconfiguration, and that allowed the data of children to be collected without consent. And even though it was something which was not entirely intentional, right? It was a misconfiguration. They didn't understand how it worked and so forth. Well, the California Attorney General said, well, it doesn't really matter, because as the developer of the app, they are responsible for the SDKs that they use and so forth. So they are responsible for the misconfiguration, and that's it. So I would say that this definitely puts a bit more spotlight as well. Is to you have now, as a developer, you do have this obligation as well, right? To develop of a website, develop of a mobile app, and so forth. You have to understand what's going on. You cannot just rely on the fact that it's a third-party solution and therefore you're not responsible. No, the authorities have said that you are going to be responsible, and I think we're just going to be seeing more and more of that going ahead. And as you say, the ad tech space is a very it's evolving, right? It's complex, it's evolving, and so forth. But then it does mean that regulators are also trying to understand what's going on in this space, and they are teaming up. There was this, in my view, a big announcement as well just last month from the California Privacy Protection Agency, announcing that they were teaming up with the French Data Protection Authority, the CNIL. They have signed this cooperation agreement, so they are going to be collaborating much more to understand new technologies. They are going to be, working more closely together, and it does indicate as well. I think willingness from the authorities to to work together to understand what's going on, and also to try to keep up with new technologies and so forth.
Yeah, in a way, it looks like those privacy laws are triggering innovation in a way, and innovation is then triggering new privacy concerns that will eventually be addressed in a law. That's a bit of a chicken and egg situation as well. But I think that's a really good outcome for everybody. I think we can move on to the CTV. I'm just being conscious of time. The CTV discussion, Julia, because I'm not necessarily the most familiar human being when it comes to connected TV, and also because it's been something, it's fairly new, CTV, in a way. It's been I think 5 years, maybe a bit longer, that people are discussing it. But it's really become big in the last few years. And we've heard actually that connected TV was, I think, going to go past linear TV in terms of investment. I don't know if it has happened yet, or if it's about to happen in 2024, 2025. What do you think is the most challenging, from a compliance standpoint, at least, given the specificities of CTV? Where do you think there is a gap that people and lawyers, especially at companies, need to fill in?
I think there's two things. First is the data that is generally being collected, used, and shared in the space tends to be classified as more sensitive under certain laws, especially in the US. So, for example, there's the Video Privacy Protection Act in the US. I think it's called the Blockbuster Law or whatever. And that requires consent to share video viewing data. And then the second one is ACR, so automatic content recognition, is data that is collected by many of the device manufacturers, hardware providers, and some third parties that provide software to different companies in the space. And that data, the US government, the FTC, and others, have made it very clear that there are higher standards and consent is required to use and share that information. So that's just two examples. There are many other things that increase sensitivity on devices. Obviously, there are children that watch TV, and so we run into a lot of the same requirements and challenges that mobile app providers, gaming providers run into. That's another bucket of data. And then the second thing that people tend to find challenging in the space is the fragmentation of identifiers, and then the way that data is shared. So the way data is shared, I'll take that one first. It is a legacy industry, as you said. Linear TV has been around for decades, and we've slowly been moving into the connected TV space. And many of the companies that operate in the TV space just are not used to a lot of the privacy requirements that exist, because much of the data that was used historically was considered anonymous, or was heavily kind of locked down and not shared the same way data is shared in the digital space and even in the mobile space. And then the second is we don't have the same identifiers that exist in the mobile space and the display space. So display, we were just talking about cookies, at least historically, was a little bit easier. Most people relied on first or third party cookies. And then in mobile, the majority of the world is operating on the Android operating system or Apple. And so there were standardized advertising identifiers. But in the TV space, there are many more, companies and manufacturers, and everyone kind of understands the strategy around having their own identifiers. So there are different identifiers for advertising. There are different identifiers that are used. We also have all the app providers that sit on top of the hardware providers. So there's frankly just kind of a bit more confusion around which identifiers are even being used and shared, depending on who owns the ad space and how it's being sold. And then the third thing is, again, I think because the CTV space came along a little bit later than display and mobile, strategically, many companies in the space, whether they're a publisher, a brand, or a hardware or software provider, kind of recognize the strategy around not necessarily sharing their data as broadly from a competitive perspective. So again, it makes it more challenging to figure out how media is bought and sold, how planning is done, how you can do measurement and all of that. It's a really interesting burgeoning space, but there's a lot of differences people need to think about.
And is the industry working on protocols or at least ways to communicate a bit better between players?
That's a great question. There certainly are some tables, some industry tables, where those conversations are going on. Some of them are the more traditional tables that you and I have sat at and worked through, and Paul, I'm sure, has in his clients, like the IAB, the ANA4As, NAI, you name it. But the bigger players in the CTV space come from a different industry, whether you look at the manufacturers themselves, which tend to be kind of a combination of legacy, very, very legacy hardware players, and the likes of Google, Amazon, Apple, and then folks like my company that are kind of very small and just starting out. And then the actual streaming service providers are also a combination of kind of upstarts like the Netflixes of the world, and then they're very big legacy cable and content providers. So they have different tables that they're used to sitting at. They have a different tolerance for competition, antitrust, concerns, and also a different tolerance on the other side of, frankly, seeing the strategy behind not standardizing protocols and standards. And then, they also just don't always necessarily understand the technology and the challenges, as well as I think a lot of us who spent decades in, the ad tech and more traditional display and mobile space.
And do you think it would be the revenue generated or the ad spend, the dollars spent in CTV would be much higher if there were those protocols and already some standards that exist for people to share data and make actually the inventory more valuable in a way?
Yeah, it's a good question. I mean, I think it's definitely one of the pillars and one of the things that the industry really does need to work on. And again, it's not just from a compliance and a privacy perspective. You and I have talked about it. There are a lot of coalitions. There's a lot of work being done to innovate on cross-platform measurement, cross-platform planning. And many of those are coalitions that have been spun up and created by many of the biggest players in the space. So they've created those tables. I think the other thing is it is just a change in behavior of how the big cable companies, content providers, and brands buy and sell media. The way that media was bought and sold in the more traditional TV space is very different from how ad inventory was traditionally sold for display and even mobile. And so there are just changes afoot there, and you need to shift budgets into CTV. And in order to do that, the brands and agencies need to know that there are ways to measure, hit KPIs, and see the benefit of their spend in TV. So it's sort of this vicious cycle. Paul referred to chicken and egg, same thing going on in the TV space.
And so regarding the KPIs that advertisers and agencies are looking at in terms of making sure that the their campaigns are actually performing well on CTV? Like, is there something in particular that they are being meticulous about, or like they really pay attention to making sure that people don't just turn the volume off during the advertising session or something like that?
Yeah, I mean, you and I were talking about, right, there's a lot of conversation around attention metrics and how to measure those. And we had this conversation, I think, a decade ago. You and I were probably working on some viewability metrics back at one of our former companies. And we actually bought a French company to do that, which is how you and I met. So that, that was that had to do with like tracking technology to see user activity with their remotes and other technologies on a browser, but in TV, there are different metrics that are being discussed, and they certainly increase and bring with them compliance challenges like privacy, because many of those solutions rely on opted-in panels of users who are willing to allow a sensor, for example, in their home, or even allow cameras in their home to kind of watch, what they're doing. It's sort of taking the old school Nielsen methodology, EDO, the others like that, and increasing the technology around that. So, we'll see where that goes, certainly. We're watching that as a company. We're being very careful and frankly don't really want to go down the more aggressive routes right now. And the people who tend to be doing it are some of the more legacy players that already have users in their panels, who are being paid to operate and participate in these types of
that sounds very intrusive. I don't know, Paul, like, what do you think about that? Like, do you think that's a good way to approach things? It feels like in Europe it would never happen, so that's why I'm being curious about what's going on in the US and how lawyers and especially external counsels are approaching this.
I will say there are some European companies working on this that I know
really?
of. Yeah.
I haven't heard about it. Okay. You're on mute, Paul. Sorry.
Right. Yeah, it is a tricky area, and in January, the California Attorney General actually announced that they were launching an investigation into streaming apps and devices. So they didn't say connected TVs, but then it's not too far of a stretch for them to also look into connected TVs as well, right? But then even in relation to streaming apps and devices, like they call it, the regulatory focus, from a California standpoint is, what are the capabilities for opting out from the disclosure, the sharing or selling of consumer personal information. What can individuals do if they want to opt out, and if there is difficulty for users to be able to opt out, if they cannot stop the selling or sharing of the personal information, then it is going to lead to some regulatory enforcement action. Now, some of you may be saying, well, there hasn't been too many enforcement actions from the California authorities. So why should we get worried about it as well? The focus from a California or from a US standpoint isn't necessarily on issuing a fine directly. It's more a question of, well, are they able to fix things? And that's what the California authorities have been doing so far. They have been sending those notices of non-compliance as well to lots of companies, or sending questionnaires. And whenever there are different issues, they wouldn't necessarily jump on imposing a fine. Instead, they would be trying to work with those companies to resolve it. And in many cases, if the company is able to fix things within 30 days, then the case is closed. It's non-public, so it's not going to be shared and so forth. So you don't really know that this has taken place behind the scenes, but it does. There have been quite a number of notices and enforcement actions which have been taken behind the scenes. Now, I mentioned 30 days. Some of you may be thinking, does it mean that we can always do this or whatever? No. We used to have a statutory 30 days right to cure that was in the original text of the CCPA. That has gone now. So you don't have any obligation from the authorities to do that. But then they have the discretion if they want to do it. And if the violation is not too major or whatever, they can take this decision not to impose any fine or whatever. They can take the decision to give you 30 days to fix things, but then they don't have to do that. And for most companies, they have been able to so far benefit from this opportunity to cure, but then that has not always worked out for some companies, and that's why we do have some big enforcement actions in California, because either the authorities chose not to give the companies the opportunity to cure because of the extent of the violation, or otherwise because it was just not possible for the organization to fix things within 30 days due to how massive the violation was.
Good. So it's really work in progress. I think in Europe as well, like this has not yet become a completely addressed topic yet, but I'm sure it will become one. But what makes it a bit challenging as well is that each market is a bit different. Connected TV space is actually very different in each market, and so it makes it even more challenging to navigate, I think, for companies. I wanted also to flag that Google, at least in Europe, has added requirements when it comes to CTV, and so now companies are gonna have to operating in the CTV space are going to have to adopt a CMP that's complying with some of the requirements that Google have set out, and so it's usually complying with the TCF in Europe, and so I think the deadline is June 2025, so there's still a bit of time, but Google will probably, for all the publishers that are currently relying on CTV, they will enforce this. Let's talk a little bit about the current state of affairs when it comes to U.S. state laws. There's a lot going on. There's also there's many deadlines. Every couple of months now, there is a new state law coming into force. It's kind of hard to navigate from afar, to be honest. But also, I think this proliferation. So on top of the technical challenges linked to inherently linked to innovation, we've got this. This proliferation of state laws and the new draft of the privacy, the federal privacy law, the APRA. First, I want to ask a question straight to with respect to APRA. Do you think that's going to pass before the presidential election? I've got a little idea on that, but my own thoughts. But I wanted to ask you, Julia, maybe.
I'm curious to hear Paul's point of view because I'm sure he has a million clients asking him. I keep one eyeball on it at least. No, I don't think the U.S. government is capable of passing much of anything. And while there are a few pieces within that legislation that folks can agree on, there's not enough. And now that everyone is heavily distracted with the election, I highly doubt it's going to pass.
So it's too late, basically.
It is. Yeah, I mean, it's not only too late, it's, we'll see when and if we ever have an environment, maybe in the next decade, that allows us to pass anything, that is actually useful. And Paul can talk to this, given that many of the states, particularly California, kind of got out ahead of federal legislation, it's going to be really hard to get those pretty powerful states to agree to anything that waters down any of the rights that they've passed and have been enforcing now for a couple of years. And so even if we do get federal legislation, eventually, I think most of us, unfortunately, think we're still going to have many state laws that we have to comply with.
Okay, so what you're saying is basically we have no reason almost to expect a federal privacy law or legislation in the next 5 years, for example.
I don't think so. And I think if we see something again, and we're going to still have state related laws, and we would always have, breach laws and things like that. We're never going to have a GDPR, is my opinion. But, I think we really will have a fairly watered down federal law if we get to see one. But maybe Paul has a different opinion. So curious to hear.
Yeah. So, two things. I'm not necessarily as pessimistic in relation to having a federal privacy law at some point. I think it could happen because we are seeing definitely more and more state privacy laws, right? Even the table which which appears on the video, the deadlines, it's not because of the pace of the adoption of a new state privacy laws, it's no longer up to date as well, because there have been new laws, and now there are almost 20 state privacy laws. So, because of this massive adoption, and the numbers going to keep continuing, to grow over the next couple of months as well. I think at some point there is going to be bigger and bigger push to have a federal law, because it's just too complex, right? The laws are similar but not identical, and it does make things so much harder for organizations to comply, because you have to make sure that you don't do something which is in violation of a state law or whatever. So, I'm not saying that you have to necessarily have a state-by-state approach, for everything, but then definitely organizations need to assess to what extent different state privacy laws change anything compared to where they stand, and this work is frankly quite time consuming and so forth, and I think this is definitely going to push organizations to lobby more and more for a federal privacy law. Now, in relation to the the current draft, the APRA, the American Privacy Rights Act, I think that one is not going to pass this year. It's highly unlikely at this stage, because there is too much pushback at this stage. I think nobody likes the draft, and the latest version of the text, the latest draft, does remove quite a number of points which were important for civil rights group, because you have anti-discrimination protections which were gone, AI impact assessment requirements which have been removed, the ability to opt out of AI decision making for major economic opportunities like housing and credit, that's gone as well. So you do have a watered down version, and as a result, you do have a few big civil rights groups who have already now recently publicly stated that they oppose the current text. And you do have as well states, California, for example, earlier this year as well, they did publicly issue a press release where they did say as well that they oppose the current text. And some of you may be surprised, saying, well, wait a minute, didn't you say that that California has a privacy law, so why would they oppose a privacy law? Well, they oppose it because, like Julia mentioned, it is the federal law is a watered down version of the CCPA. It doesn't have the same protections and so forth, and that's why California is against it, because the federal law would actually require one single standard across the U.S. So it would be setting a ceiling, if I can call it that way. Would be the maximum requirements, and states can't go beyond that. And of course, a number of states like California, who have already adopted their privacy law, they are not in favor of such a privacy bill, which would water down what they have already done. They have done their own recipe. They have already adopted the law in the states, and they don't want to change. They don't want something which would erase the efforts that they have done in terms of privacy rights and so forth. So if you have a privacy law in state which would say, well, this is the minimum requirements, but then states are allowed to go beyond that, well, you would definitely have more. You would have more states in agreement with that. The problem, of course, is that having such a federal law would not make much sense, right? Because, I mentioned earlier, well, too many state privacy laws. So if you still have, 20 plus state privacy laws, and on top of that, the federal law that you have to worry about, well, from an organizational standpoint, it doesn't help. So that's, the difficult situation that we are in right now, where nobody can really come to an agreement, on whether or not the federal law should impose a single standard across the U.S. or whether it should or should not. And then could actually be one of the the reasons why we're not seeing any why there isn't any and why there may not be any federal law in the near future as well, because of this disagreement, which seems quite difficult to overcome. Even now, a lot of folks were optimistic about this federal law because it's election year and so forth, but then I don't think it's going to happen.
So people and companies are going to have to comply with like all the state laws for at least another year or another couple of years, depending on whether you're pessimistic or optimistic. In the ad tech world, what does that actually mean for companies, especially since like despite the fact that the state laws are similar in a way, they also sometimes refer to concepts that we've seen in the GDPR context, but that's not the case in California, for instance. So we don't have the controller and processor situation. It's more like business service provider. Anyway, the concepts are a bit different. The requirements are also different. The opt-out rights are often different. How do companies, especially in the ad tech industry, operating across the US in many states, how do they comply? In practical terms, what's the best way to build a privacy compliance program with all that complexity on top of the technical complexity that we already discussed?
Yeah, there isn't a standard approach. So, you mentioned California has its own terminology of business and service provider. As surprising as it may seem, most of the other states have actually adopted the European terminology. They have adopted the controller processor approach, which is great in terms of simplification, right? Instead of having to learn new terms and so forth. But then in terms of the requirements per se, what you are supposed to be doing, the privacy rights and so forth, they have followed the California approach. And you do have, like I mentioned earlier, one of the big focus in the US is in relation to the opting out of the disclosure of information to third party, the selling or sharing of personal information. So that is something that that we have seen in most of the different state laws. They may not necessarily have an identical definition, but it's close enough to what we have in California. So in terms of compliance, I would say that organizations should look at and just comply with the most stringent approach and go further. And in terms of the most the strictest standard, I would say it's probably still California at this stage. But then you do have some other states like Colorado as well, which are quite close behind as well. Colorado has adopted implementing regulations as well. They have actually been the first one in the nation to have an AI legislation as well. Have developing a framework which would be complying with a mix of California, Colorado, and then just taking a look at some other states. I think that's the best approach at this stage, so that you can comply with the different state requirements. And in terms of the requirements as well, some organizations may be tempted to say, well, you know what, maybe we can just adopt a state-by-state approach. So California and Colorado are strict, so okay, we're going to be adhering to those, and then for the other states, we're going to have a watered-down approach or whatever. I would not necessarily recommend that as well, because at the end of the day, it's still the same country, right? So from a commercial standpoint, how are you going to justify to a customer, well, your cousin who is living in California, we're giving him all of those rights, but then, sorry, you live in another state, we're not going to give you those rights. It is difficult commercially to do that, and that's why a number of organizations, they have started to taking a uniform approach and saying, you know what, we're going to, in terms of privacy rights and so forth, we're going to be taking more uniform national approach or whatever. We don't necessarily have to do it, but then it's just difficult commercially, not to do it. And in any case, does the organization really want to have 20 different processes in place, 20 different approaches in terms of how to handle privacy rights and so forth? Maybe not, right? I think the company resources will be better used elsewhere. So, that's why organizations have said, well, okay, well, we just adopt a single approach within the US, where the most, some may make a distinction between California and then the other states, but then it's just too much work to have to do different things for each different state.
Julia, do you agree with that?
Yeah, I think I tend to hear from most companies that they take a FIPS, like a Fair Information Practice Principles based approach globally, and kind of map to either the strictest standard globally, or they pick kind of two and map to those. And to Paul's point, they apply them across entire countries, and it just makes it a lot easier to standardize, and also to, frankly, you talked about this, but to explain to your business folks, especially engineers, product managers, you name it, what the requirements are and the spectrum of requirements for each requirement, much easier to build to and actually support.
That makes sense. Again, looking at time, I think it's about time to maybe check whether there is any question. I actually don't think there is any. So maybe I'm just, all that's left now is to thank you both for joining this webinar and for providing really interesting and in-depth insights regarding the current state of ad tech innovation in the US. We will probably, if there are any follow-up questions, we can address them, and we can I think close it here 5 minutes before the end of the hour. So that's perfect. Thank you so much, Julia and Paul.
Thank you.
Thank you for having us.